Once again, you are welcome to this presentation series on criminal law. Today, we are looking at parties to an offense, and we'll begin looking at the various situations in which a person may be a party to an offense. Under the criminal code, a person can be a party to an offense in 4 different situations. And in those situations, the person can be charged with committing the offense. The first scenario is when a person is the one who did the act or made the omission that constitute the offense. The second scenario is where a person does something for the purpose of aiding another to commit an offense. The third scenario is when a person aids another in the course of committing the offense. The fourth scenario is when a person procures, counsels, or advises another to commit an offense. These are the 4 situations that will make a person a principal to an offense under Nigerian law. And then we'll go on to look at other aspects of parties to an offense. In a minute, I will share my slides so that we can go through the lesson together. Just give me a minute to share my slide. My name is Akeem Olajide Bello. I'm of the Department of Public Law, Faculty of Law, University of Lagos. The learning objective for this presentation on parties are as follows. Number 1, we expect that at the end of this presentation, students should be able to understand the rules governing when a person may be held liable as a principal offender, the rules governing when liability for instigating the commission of an offense to entrap an offender, the rules governing liability for offenses committed in prosecution of a common purpose, and the rules governing liability as accessories after the fact and for neglecting to prevent a felony. We expect also that at the end of the lesson, the students should be able to do the following with the knowledge they will acquire through this presentation. Number 1, explain the rules governing when a person may be held liable as a principal offender. Explain the rules governing liability for instigating the commission of an offense. Explain the rules governing liability for offenses committed in prosecution of a common purpose. Explain the rules governing liability as accessory after the fact and for neglecting to prevent a felony. Now, I want us to imagine a scenario of different individuals playing different roles in the commission of an offense. For instance, let's imagine a situation of 4 individuals who are involved in the commission of an offense. A is a person, it could be in the situation of, usually when you have parties to an offense, it is also a situation of a conspiracy. We've earlier looked at the offense of conspiracy. You may have A, who is a mastermind, who recruits other persons to form part of the conspiracy. Maybe, for instance, A, desiring to rob a bank, recruits B, who is an official of the bank. His own role in the offense is to leave the vault, the bank's vault, the door to the vault open, or to give the security code that will enable the robbers to open the vault. That's the role of B. Then C may be an expert drive away, an expert driver who is, very adept at driving cars, through any situation. So he is the one that will be waiting in the vehicle outside the banking hall to take the robbers to safety after the robbery has been committed. While D may be another person who is the one that is the originator, the main originator of the idea, is the one that even informs A of the idea. He is the one that informs A, is the one that got in touch with B, is the one that got in touch with C, and played an active role in bringing everybody into the conspiracy. So we find in this situation 4 different individuals. Now, A is the only one who will go into the bank to effect the actual robbery. B provided the security code that will enable A to open the vault of the bank. C is a driver who will drive A away from the scene of the crime. Now, D is not going to be physically involved at all in the robbery. All that D had done is to gather together all the parties. He is the one that recruited A, is the one that recruited B, is the one that recruited C, is the one that brings about the entire plot. Now, all these parties, all these persons that I've mentioned, A, B, C, and D, they are all parties to this offense of robbery. Any participation by A, B, C, or D, although their roles are different, their participation renders each of them liable as a principal offender. It renders each of them liable as a principal offender under Section 7 of the Criminal Code. And what that means is that each of them may be charged and tried for the offense of robbing the bank or stealing from the bank. It does not matter that A only recruited the others. It may even be abroad at the time the offense is committed. A will be liable to be charged for the offense. A, the person who actually did the act or make the omission. A is the one that went into the bank, used the security code to open the vault. A may also be charged as a principal offender for committing the offense. On the other hand, B, who is a bank official that gave them the security code that enabled them to open the vault of the bank, even if on the day of the offense, he was sleeping at home in his house, or he took a leave of absence to be away from work so that people will not suspect that he's involved. He also is a principal offender and may be charged for actually committing the offense. And then our friend, C, who is the driver, he did not enter the bank premises. All he did was to wait for A in a vehicle outside the bank to drive A away to safety after the robbery. C is also a principal offender and may be charged and tried for the offense. So let's imagine a scenario in which A, B, C disappeared after the robbery, and it's only D, the person who brought everybody together, that was arrested. He will be charged with the offense of robbery. Let's also imagine that B, C, and D escaped after the robbery and ran away outside Nigeria, and it is only B that was arrested. B will be charged and tried for the offense. Let's also imagine that it is only C that was apprehended by the police. All the others escaped. Although C did not enter the bank premises, it was only waiting in the drive-away car, he will also be charged with the offense. So any of the parties who has played any of these roles that have been identified can be charged with actually committing the offense and punished as a principal offender. Okay. Now, so we'll look at the provisions of Section 7 of the Criminal Code that captures the role of all the parties to an offense and categorizes them as a principal offender. Section 7A. Section 7A provides that every person who actually does the act or makes the omission which constitutes the offense. Now, like we have said in the example that I gave, B is a person who actually does the act or makes the omission which constitutes the offense. B is a person that entered the bank premises, used the secret code to open the vault of the bank, and actually effected the act of stealing from the bank. So A in our scenario, A in our scenario is the person who does the act or makes the omission which constitute the offense. A is a person who does the act or make the omission which constitute the offense in the scenario that I've given. Now, it's important when we are reading Section 7 to note that it appears that Section 7 only captures the actus reus of the offense. It appears that it only captures the physical elements of the offense by merely saying the person who actually does the act or makes the omission which constitute the offense. But the provision is not interpreted in that way, because in addition to doing what constitutes the act or what constitutes the omission, the person must also have done the act or made the omission with the requisite mental element that is required for the offense. We will note that in the provisions of Section 7A, there is no, and indeed in the provisions of Section 7B and C and D, there is no reference to the mental element required to render the party liable as a principal offender. There is no reference to the mental element that is required to render the party liable as an offender under the offense. You know, Section 7 is only about parties. The provision that deals with the offense committed is another provisions of the Criminal Code. There are other provisions of the Criminal Code that defines the offense itself. Ordinarily, those provisions will set out the mental element and the physical element of the offense. So what Section 7 is only concerned with is defining what makes the offender a party to the offense. So Section 7 does not go the whole way to define the mental element required to make a person a party. The mental element required to make a person a party to an offense will be defined by the provision defining the offense. So in Section 7, there's no reference to the mental element required to render the party liable as a principal offender. As I've said, the mental element required to render the party liable is already defined under the provision creating the offense. So in interpreting Section 7A, the law will bear that in mind, and the court will require that the offender, in addition to doing the act or making the omission under Section 7A, he must have done the act or made the omission with the requisite mental element that the law provides for the offense. So in other words, when the courts are interpreting Section 7A, they will interpret it along with the provisions that generally requires the mental element of an offense. And one of those provisions that generally requires the mental element of an offense is the provision of Section 24 of the Nigerian Criminal Code, you know, which says that subject to the express provision of this code relating to negligent acts and omission, a person is not criminally responsible for an act or omission which occurs independently or of the exercise of his will, or for an event which occurs by accident. Now, that provision is a provision that, equals a general requirement of mental element required for an offense under Nigerian law. So the court stated in R and Solomon, R and Solomon is a Queensland case. It's an Australian case interpreting the equivalent provision to Section 7 under the Queensland Criminal Code. So the court said in R and Solomon, 1959, Queensland reports, page 133, the court held that the equivalent provisions in Queensland Criminal Code to our own Section 7 and 24 of the Criminal Code should be read and construed together. In other words, the court should not read Section 7A, B, C, D in isolation. The court must construe it, by combining it with Section 24. And Section 24 is a provision that generally, is the equivalent of a general requirement of mental element under Nigerian law that equals the provision of mens rea under the English common law of crimes. So what it then means is that for a person to be liable as a party under Section 7A, he must have done the act or made the omission. But in addition to that, he must have done the act or made the omission in addition to having the requisite mental element that the law requires for that particular offense. No. So in the case of R and Idiom and Umu, the court made this point very, very clear. And the court stated that the provision is not designed to criminalize the conduct of an innocent agent of another's criminal intent. So if you are an innocent agent, you have done something which constitutes an offense, but you did it innocently without the requisite mental element required for that offense. Although you have done the act or made the omission which constitutes the offense, you will not be liable under Section 7A as a party. The person who procured you, the person who recruited you, or the person who made you to do the act or the omission with the requisite mental element required for the offense, he is the one that will be liable. And this case of Arad, Idiong, and Umu clearly, explain the workings of this provision. Now, in that case, the second defendant was a herbalist. And, one of the roles, the duties of an herbalist is they make concoction, they make herbal medications, for people to take to improve their medical condition. So the second defendant was approached by the first defendant. The first defendant brought a pregnant woman. The intention of the first defendant was to procure herbal medication from the second defendant to administer on the pregnant woman for the purpose of aborting the pregnant woman's pregnancy. But the second defendant did not know this. The first defendant approached him and said, look, this woman is having some stomach ache. Kindly prepare a medication to relieve her stomach ache. And the second defendant prepared some herbal medication and administered it on the woman. And that resulted in the woman's death. And they were charged with, having committed the offense. And ordinarily, what the second defendant did by preparing the medication will have made him to be a party under Section 7A because he is the one that has done the act which constitutes the offense. But because he had no criminal intention, he was an innocent agent of the first defendant's criminal intent, he was not held liable. It was the first defendant that was held liable. So that is how Section 7A operates. So it is not enough that the offender has done the act or made the omission which constitutes the offense. He must have done it with the mental element required under the provisions of the code creating the offense. And of course, we know that Section 24 of the Criminal Code is one of the general provisions that apply to all offenses. is one of the general provisions on criminal responsibility that applies to all offenses under the provisions of the criminal code. Now we want to look at liability as principal offender under section 7B and C of the criminal code. Now, under section 7B, it provides that every person who does or omits to do any act for the purpose of enabling another person to commit the offense. So if you have done something and your purpose is to enable another person to commit an offense, then you are liable under that provision. In the example I gave at the beginning, in the scenario of the people trying to steal from the vault of the bank official who gave the other party to the conspiracy the secret code that will enable him to open the vault of the bank, has done something for the purpose of enabling another to commit the offense. That's the provision of section 7B. Now, section 7C is also similar, but differently worded. It says every person who aids another person in committing the offense. That's section 7C. Now we'll look at it a bit more closely and we'll see the similarities and the differences between section 7B and section 7C. Section 7B and C relates to aiding another to commit an offense. Now, in section 7B, anybody who comes under section 7B is aiding another person to commit an offense. Although his own is that he has done something for the purpose of enabling the person to commit the offense. Under section 7C also, the person is also aiding another person to commit an offense. Although what he has done is to aid the person at the point the person is committing the offense. The one in section 7B is doing something for the purpose of enabling. That's before the commission of the offense. While in section 7C, it talks about aiding another to commit an offense. In other words, something that is done contemporaneously at the time the offense is being committed. An aid provided when the offense is being committed. So section 7B relates to a person who does or omits to do any act for the purpose of enabling another to commit an offense. Aid before the offense. While section 7C relates to a person who aids another person in committing the offense. Aid contemporaneous with the offense. Aid rendered at the time, at the point in time when the offense is being committed. Now, in both B and C, an assistance is provided to facilitate the commission of an offense. That's what is common between B and C. Under section 7B and C, the prosecution is expected to prove, again, the mens rea of the offender. Just like section 7A. Under section 7B and C, the prosecution must prove the mens rea of the offender. So it's not enough for me to do something to enable another to commit an offense, or for me to do something that actually aids that person at the time of committing the offense. I could have done it innocently, just like in R against Idiong and Umo. So for a person to be rendered a party under section 7B and C, the prosecution must also prove the mens rea of the offender. In other words, the prosecution must prove the mens rea or the mental element required for the offense under the provision of the law creating the offense. You can see the case of NCB and Gamble, 1959, 1 QB versus 11. The court held that intention to assist or encourage had to be proved in addition to the knowledge of the circumstances. Now, in the Nigerian case of Iyaro and the state, intention to aid was found to have been proved. That was a case of a lady who entered a taxi in the night. She entered the taxi. Unknown to her, the taxi driver and two occupants of the vehicle, of the taxi, were all robbers involved in a conspiracy to pick people with the taxi in the night and rob them. So the lady entered the vehicle, and the lady, at some point, at a pre-arranged location, the driver stopped and the lady was robbed. So at some point, the robbers wanted to leave, and the driver used his horn to beckon to them that you have not finished the job. They came back and concluded the job and escaped. Unfortunate for the driver, unfortunately for him, he was arrested. The court found that, of course, by using his vehicle to carry the lady for the purpose of enabling robbers to rob the lady, he was a party to the offense. And not only that, he was a willing party, because his conduct in beckoning to the other robbers that the job is not yet concluded showed that he was, part of the conspiracy, and he had an intention to assist or aid them to commit the offense. And he was convicted of armed robbery and sentenced to death, for providing the aid to the robber. Now, what is the liability of A, where he offers assistance to B to commit a particular offense, and B commits another offense? A may not be liable. It depends on the circumstances. If A gives his vehicle to B to go and use the vehicle to commit an offense in a particular location, maybe to go and commit the offense of assault on a particular individual, and A drove the vehicle to another point and used the vehicle to take away stolen goods. Okay? Now, the person who gave him the car would not be liable for the vehicle being used to convey stolen goods, because the vehicle was given for the purpose of enabling him to get to a location in which he intended to assault another person. Now, if A assists B to commit an offense and B commits a lesser offense, A may be liable for aiding him. For instance, if you know that a person wants to kill another person, and you gave him your gun to use in carrying out his murderous plot. Unfortunately for the victim, the bullet did not hit him at a place that will result in his death, so he survived. Now, that is definitely a lesser offense. So the person you gave the gun may be charged with the lesser offense of attempted murder. And because you gave him the gun, and attempted murder is a lesser offense to the offense of murder, you may be liable for aiding him to commit the lesser offense of attempted murder. Where A sells a gun to B, knowing that he was going to use the gun to kill or rob, he will be liable, although he did not know the precise details of the offense. So if you give your gun to somebody and you know that this guy wants to go and use the gun to kill or rob somebody, even if you don't know the person who is going to kill, or you have no information, full information as to how he's going to carry out the act of killing or the act of robbery, you will be liable for the offense, even though you did not know the precise details of the offense. You can see the English case of R. and Bainbridge, 1961 QB 129. Another question that we may ask is, should the assistance rendered have enabled the commission of the offense? Section B and C is talking about aiding, giving assistance to commit an offense. Now we're asking the question, should the assistance rendered have enabled the commission of the offense under Section 7B? Now, if you look at the way Section 7B is drafted, the wordings of the provision, it talks about aiding another for the purpose of enabling the commission of the offense. Aiding another for the purpose of enabling. So it appears that the emphasis on aiding for the purpose of enabling. So if you aid to enable somebody, for instance, giving somebody you know is going to, who wants to go and kill, giving him a gun to go and use to kill, may appear to have fulfilled the provisions of that provision, because it says you have done something to enable another. The person may not have actually carried out his objective. So for enabling, it appears that the provision may be wide enough to cover that kind of scenario. Now, what is the position under Section 7C? In other words, under Section 7C, should the assistance rendered have enabled the commission of the offense? Under Section 7C, it was held in Eweoye and R, 1955-15 Waka page 1, that there must be a clear evidence that the appellant did something to facilitate the commission of the offense. So if you have done something to facilitate the commission of an offense, that may be sufficient. That may be sufficient. Now, but if the offense is not committed, if ultimately the offense is not committed, then, of course, it follows that the person who aids cannot be charged for an offense that was not committed. Okay? But that aid, the question then will be, what will be the liability of that person for aiding another person to commit an offense that was not committed? Like in the example that I gave earlier, he gave out a gun to somebody, knowing that the person was going to use that gun to kill. But maybe the person later changed his mind. So what will be the likely liability of the person who gave him the gun? Now, he has clearly done something for the purpose of enabling the commission of the offense. So what likely offense will they have committed? Of course, you can't charge him for the main offense because the main offense has not been committed. So does that mean that the person who aided for the purpose of enabling the commission of an offense will go completely scot-free, having done something to aid the commission of an offense, knowing that somebody intended to commit an offense? I think the answer to that may be found in the fact that the two of them may be liable for conspiracy to commit the offense in question. Because here, there are two people involved. The minimum required for conspiracy. There is a kind of an agreement to commit an offense because the person needed a gun to kill. The other person has given him a gun to enable him to kill. There is consensus added. What they have agreed to do is an offense. And you remember that in conspiracy, the main offense need not be committed. So I think that is that will solve whatever may be any loophole that the offender may want to use to escape from liability there. Now, under Section 7C, the prosecution must prove that the defendant intends, while assisting in a crime, to give that assistance. Again, we have said that this earlier. Under Section 7A, there must be evidence that the offender intended to do the act or make the omission. It's not just enough that he did the act or make the omission. Under Section 7B, there must be evidence that intended to aid another for the purpose of enabling the commission of the offense. And similarly, also under Section 7D, Section 7C, the prosecution must prove that the defendant intends, while assisting in a crime, to give that assistance. You can see the case of Enweyi and R, referred to earlier, and R and Solomon. Now, under Section 7C, a question may arise, and this is very interesting. A question may arise as to whether the aid was given during or after the commission of an offense. Now, if the aid was given after the commission of an offense, if the offense is already completed, then the person cannot be a party because the offense has already been completed. The commission of the offense has already been completed. So the question may arise as to whether the aid was given during or after the commission of an offense. If the aid was given during the commission of the offense, then that implicates Section 7C ordinarily, because Section 7C talks about aiding another to commit an offense. So if while the person is in the process of committing an offense and you aided him, then you are liable. Now, let's look at the case of R and Mabry. Very interesting Queensland case. 1973, Queensland Report, page 211. That was a case in which a rape was ongoing. The offender was raping his victim. He was having unlawful sexual intercourse with his victim without consent. And as he achieved penetration, the lady cried out. And there were two other people nearby, the friend of the rapist and the friend of the victim. So when the lady cried out, the friend of the victim, a lady, wanted to go to the scene of the crime and assist her friend, maybe to push the guy off or to, drag him off or something. Then the friend of the rapist restrained the lady, the friend of the victim, from going to assist the victim who was being raped. Now, so the friend of the rapist was charged along with the rapist for the offense of rape, for aiding the offense of rape. And you know his argument? His argument was, well, the offense of rape is complete upon penetration. That the moment the offender achieved penetration, the offense is already completed. And because the offense is already completed, he has no liability as a person who has aided the commission of the offense of rape. That was a very brilliant and mischievous argument. The court said, well, of course, ordinarily, the offense of rape is complete upon penetration. But what goes on after penetration is still the offense of rape, because the man is still inside his victim. So the offense was still continuing. The offense did not end with the act of penetration. And because the offense did not end with the act of penetration, the offender is liable for aiding his friend in committing the offense by restraining the victim's friend from going to render assistance when the rape was ongoing. That was in the case of R and Mabry. In another interesting Australian case of R and Johnson, the offender broke into a shop and was stealing inside the shop. And somebody was passing by, saw that the owner of the shop was approaching, and he quickly signaled to the offender that, somebody is coming. And the offender, quickly left the scene with some of the stolen items. His argument was that the offender had already taken the thing to be stolen, when we get to the offense of stealing, we'll see that one of the elements of the offense is taking or conversion. When the offender moves the thing that is to be stolen or causes it to move. So his argument was that the offender, having taken the thing that was to be stolen, the offense was completed, and is aiding him by telling him that the owner is approaching was still an aid or assistance rendered to facilitate the commission of the offense, and the offender was convicted as a party to the offense. R. and Johnson. Another issue that may arise under Section 7B and C is whether mere presence at the scene of crime is sufficient to make a person a party to the offense committed. So the fact that you are present at the scene of a crime, will that be sufficient to constitute aiding another to commit an offense? In Pursuit Against the State, 2011, 20 NWLR, Part 1234, page 393, and Azuma against R, 1950, 13 Waka, page 87. It was held that mere presence at the scene of a crime and failure to intervene or prevent it is generally not sufficient to render a person liable under Section 7B and C. A person must be purposely facilitating or aiding the commission of a crime by his presence before it can be regarded as an accomplice. So if your presence at the scene of the crime is purposeful and can be construed as an aid, then the person can be liable. Liability under Section 7D. Section 7D relates to any person who advises, who counsels, or procures any other person to commit an offense. So if you encourage somebody to commit an offense, or you advise him to commit an offense, or instigating to commit an offense, and the person commits the offense, then you are also liable for the offense, and you may be charged with actually committing the offense, even if you are not there when the offense is committed. If you advise somebody to go and commit offense, if you are in Lagos, and you advise somebody to go and commit an offense in Kano, and the person commits the offense in Kano while you are in Lagos, you are liable to be charged under the provisions of the law for advising or counseling him to procure or procuring him to commit an offense. You can be charged with the offense committed. Maybe after the person has now committed the offense, he escapes, and the police will not trace him. But the police have clear evidence against you that you are the one that procured it. You are the one that counseled it. You are the one that advised it. You are the one that instigated it to commit the offense. Then you will be liable. The amount of encouragement offered need not be particularly great for liability to arise. All that is important is that you have offered some encouragement for the person to commit an offense. In fact, in Arangainetu, somebody told the offender, "I am going to kill your wife." And the offender said, "Oh, goody." You know, something to the effect that that will be great. Those words were held to be sufficient to constitute encouragement to commit an offense, and the person may be charged with committing the offense. Procure means to produce by endeavor, you know, just like when you instigate somebody. Per Lord Widgery in Aegis reference, number 1 of 1975 QB, page 773. It stated that procuring required a causal link to be established between what the procurer did and what the person did. So if a procurer procured somebody to commit an offense and the person commits the offense, then then the link is established. The implication taken by the Court of Appeal in the case of R and Gianetto is that words of encouragement may be sufficient. If you offer words of encouragement to somebody and the person acted on your words of encouragement and goes ahead to commit an offense, you may be charged, you'll be liable under Section 7D, and you may be charged for committing the offense. Encouragement to commit an offense may be construed from membership of a society and participation in its proceedings. See the statement of Lawrence J. in Idika and R. If you belong to a secret society, and one of the objectives of the secret society is to kill anybody who constitute a stumbling block to their member, and a person is killed who constitutes a stumbling block to one of the members, all the members of that society may be liable for counseling or procuring one another to commit the offense. See, however, the case of R and Ukwe. In Obodo against R, the case further illustrates the liability for procuring or instigating an offense by members of a group. If you belong to a group and the objectives of the groups are clear, okay, you will be liable for any offense procured or committed by any member of that group by virtue of your membership. There is a clear example of counseling or procuring where someone in authority orders a subordinate to commit a crime. You can see the case of Ajao versus Alkali Amodu. Now, an alkali in a court, an alkali is a presiding officer of a court in northern Nigeria, ordered his police orderly to assault a person. The court was held that the alkali is liable for counseling or procuring the assault, and he was held liable for the assault. Now, the absence of the procurer from the scene of the crime is relevant to liability. I've said that earlier. What the law requires is that you procure somebody to commit an offense. You encourage him to commit an offense. You instigate him to commit an offense. You counsel him to commit an offense. You advise him to commit an offense. Once the offense is committed, you are liable. It is not the requirement of the law that you must be present with him when he commits the offense. For as long as there's a link between your procurement and the offense that was committed, then you are liable. It must be proved that the procurer intended the commission of the offense. Again, just like in A, section 7A, B, and C, the mental element is also required to render a person liable under section 7D. It must be proved that the procurer intended the commission of the offense procured or counseled. Once this is shown, it continues to be liable if the offense is committed, unless and until he expressly countermands or revokes the previous counseling or procuring. Now, what that means is that if A procures B to commit an offense, for as long as B is still looking for opportunity to commit the offense and eventually commits the offense, A is liable for counseling or procuring the offense. If A procures B to go and kill, A procures B to go and kill C, and C had been searching, B had been searching for C for over a period of 1 week. He was unable to physically locate C. And while he was still looking for C, A calls him and tells him, "Oh boy, I've changed my mind. I don't want you to kill C again. Please return the gun that I gave you to kill C." I'm no longer interested in killing C. If you kill C, you are on your own. Until it countermands his previous counseling or procuring, A will continue to be liable. If it takes C, if it takes B 4 months to physically locate and kill C, A will still be liable until it countermands or revokes his counseling or procuring. The repudiation, the countermand, or the revocation of the counseling, the repudiation must be unequivocal. It must be clear. It must not be, well, you have been looking for him for the past 1 week. Well, you can leave him, but in case you still find him, but if you want to leave him, you can leave him. But if you still want to go ahead to kill him, you can go ahead to kill him. That is not an unequivocal repudiation. The repudiation must be unequivocal. It must be clear. There must be no ambiguity that the procurer has terminated his procurement. There must be a clear repudiation, and this must be communicated to the person that was procured. Until that is done, the procurer still remains liable. And once it is communicated and the person procured still goes ahead to commit the offense, then he alone is liable for the offense. You can see the case of Okafor and the state, 1965-90 MLR 20 at page 23. The case of R and Sailor, 1963 Queensland Weekly Notes, page 14 at 36. The case of R and Grundy, 1977 Criminal Law Report, page 543. And the case of R and Whitefield, 1894 79 Criminal Appeal Reports, at page 36. Now, we want to look at instigation for the purpose of entrapment. Now, the issue here is the extent to which the law enforcement officers are allowed to participate in an offense to enable them to catch an offender or entrap an offender without the law enforcement officer now incurring liability as a party. Okay? Now, law enforcement officers, in the process of investigation, apprehension, and arrest of offender, sometimes they may need to play a role in the offense that is about to be committed, for them to be able to catch the offender, to set a trap for the offender. But they have to be careful in doing so, because if they are not careful, their conduct may render them liable as a party to the offense under Section 7. And when their conduct comes within the provisions of Section 7, they may also be charged with the offense. In other words, the law does not allow you to break the law in order to enforce it. Law enforcement officers are not allowed to break the law in order to enforce it. You can see the statement of Lord Scammer in the case of R against Sang, where the court said that, well, the courts may be willing to allow law enforcement agencies to set a trap for an offender, particularly where the offense is laid on. The offender are in the process of committing the offense. Then the law enforcement officer may pretend. For instance, if somebody calls a police officer and says, Oga, I understand you are the one in charge of this case. The case involves me, and I would like to see you to find a way of settling the case. And whatever I need to do to satisfy you or to make you happy, I'm willing to do it so that you can drop the case against me. Now, that immediately suggests to the police officer that the offender is trying to bribe him. So if the police officer says, oh, okay, no problem, I'm always available you can come to my office at 8 o'clock tomorrow morning, and then we can discuss. And then the police officer now sets up a CCTV camera in his office. So when the offender now comes and says, well, oh God, you know how things are in this country, things are hard, and we're all trying to make ends meet, you know, that's why I did this and all that. But don't worry, if you write a favorable report concerning me, and it brings out an envelope containing $500, this is your reward. And he gives the money to the police officer. And the police officer says, oh, thank you very much. Don't worry. I will write a favorable report for you. The offender does not know that the police officer is recording the events on video. And after handing the money over to the police officer then immediately arrests the offender and charges him to court for the offense of bribing, offering a bribe to a public officer under Section 98 of the Criminal Code. Now, what the police officer has done is to create a room to enable the offender, for him to catch the offender or to entrap the offender. The law allows police officers to do that. That's what the statement of Lord Scammon said in the case of R and Son. What the law does not allow is for the police officer to instigate somebody to commit an offense. Particularly, somebody who is unwilling to commit an offense. Now, in Brannan and Peak, where a law enforcement officer instigated an unwilling person to commit an offense, Brannan and Peak, 1947, to All England Report at page 572, instigated an unwilling person to commit an offense. The police officer was held liable as a party to the offense. And in the case of Aaron and Smith, somebody who claims to be fighting corruption in public service went and offered a bribe to a public officer. He was arrested and charged with bribery. And the court said, look, your intention to entrap a law enforcement, a public officer does not avail you. What you have done constitutes an offense, and you are liable for the offense. So the courts, however, accept and condone the practice of police participation. I've already explained that. In order to trap would-be offenders as a necessary part of the administration of criminal law. The court has condoned the practice of police participation to trap the offender, just like the case I stated earlier. So merely to provide an opportunity for a temptation to commit an offense may be lawful if the police merely provided a temptation or an opportunity for the offender to commit the offense, then that is allowed. In the case of Williams and DPP, 1993-98 Criminal Appeal Reports, page 709, where the bait was cartons of cigarettes left in a vulnerable position, the court held that the police had not aided the offense. Where an offense is laid on, however, it may be appropriate in some circumstances for law enforcement agencies to participate in the offense, to trap the offender. Okay? The offense is laid on. In other words, the offenders are already in the process of committing the offense. It may be appropriate for law enforcement agencies to participate in the offense, to entrap the offender. See the statement of Parker CJ in R against Battles, 53 Criminal Appeals Report, page 469, at page 473. You can also see the case of R. Adukoyi, where the court also referred to the reported case of Abaka. That case involved, somebody who wanted to break into a place, and he went and informed the police, and gave a police officer some money so that the police would not they stopped them. The officer went and reported the matter to his superior, and they laid in wait for the offender, and the offender was arrested. The court said that that was proper in the circumstances. So that is where we will end today's lecture. In subsequent presentation, we will look at offenses committed in prosecution of common purpose under the provisions of the criminal code. So today we have looked at the circumstances under the provisions of Section 7 of the criminal code when a person will be a party to an offense. A person will be a party to an offense under Section 7A, where it does the act or make the omission that constitute the offense. Under Section 7B, where a person does an act for the purpose of enabling another to commit an offense. And under Section 7C, where the offender does something to aid the commission of an offense. And under Section 7D, where the offender procures, counsels, or advises another to commit an offense. So thank you for listening to this presentation. Please take time to listen to it, and then come to class on Tuesday prepared with your questions. And if there is any area of the lecture that you require clarification, note them. When we meet in class, we will do all the clarifications and make all the explanations. Don't forget to press the subscription button to subscribe to this YouTube channel, so that when I post subsequent presentations, you will immediately receive the notification and you can listen to it. Thank you very much. God bless.